Thank you for joining us again on the Consumer Trial Lawyer Academy. My name's Nick Wooten. I've set up this YouTube channel to try to help people who don't have as much experience trying cases as I've gained over 26 years of doing this, to help you understand each phase of your case from beginning through, the appellate courts, and to help you in particular with trials. What's going to happen when you go to the courtroom. So today we're going to talk about opening statements, and I will tell you again, our focus is on federal court. A lot of this translates to your own state courts because some of the things we'll talk about, you'll understand why. You're in federal courts. Remember that process is very judge specific. As a young lawyer, I tried a lot of cases in state court, and you can get away with a little bit of Southern Baptist preacher down south when you're giving an opening statement. You can get into it a little bit and talk about things, be a little more, rah-rah, go team type scenarios, closer akin to a closing argument in some ways, with a mindset you're trying to really fire up the jury for what they're going to hear and help them start to get angry, whatever. Did that for a few years, started trying cases in federal court. I will tell you that in the opening statements in federal court, look, judges control that. Some judges will give you the time that you ask for. If you tell the judges, I need an hour, they'll give you an hour. Some judges will tell you you have 10 minutes for opening statements. Some judges will tell you have 5 minutes for opening statements. So by the time you're there for opening statements, you will have been dealing with your judge extensively for your pretrial process and all those things that go along with the time between your pretrial and your actual trial, where there's several more conferences where you clear up any lingering issues. And you will have been dealing with your judge through discovery and summary judgment, and your judge should have a sense that, hey, you're a cat that knows what they got going on, knows what they're doing, and I can trust this lawyer not to waste my time, not to waste the jury's time. And if you've demonstrated your competence and the judge is willing to give you flexibility, then you should be able to tell them exactly what you need for time, and could tell you how you can do that, so you'll know. First off, go by David Ball on damages. The thing about David Ball on damages, and in version 3 is where I'm at, which has a format for how to give a good opening statement. Here's what you need to know. It's incredibly effective. It works. And you're able to give your opening statement without resorting to anything other than just, here's the facts, ma'am. Here's the facts, sir. But you're able to tell the story in a way that will stick in the minds of the person hearing. And I can tell you that I did it for a long time without the benefit of David Ball's book, and my results got so much better by faithfully following that outline of the proper way to give the opening statement in a trial, so that the jury understands what the case is really about. What drove me to David Ball was losing a trial that I thought I should have won at a point in my life where I had not lost a trial in a long time. And it was what I thought was a good case that should have had a good outcome. And I put a ton of time and effort into it, and I got zeroed out. And I was stunned. And when that happens, if you're good at what you do and you care about what you do, you're going to start looking for answers. So I started talking to friends that I had that were real trial lawyers that gotten big verdicts and had tried a lot of cases. And one of my closest colleagues said, "You need to read David Ball on damages." And so I bought it. I didn't have anything else to do. I wasn't going to be defending a verdict. No, there's no post-trial motions for me to file. I'd lost. And there's nothing that was going to change that. The jury had just decided that we didn't have the evidence to win. The reason that I was so particularly disturbed was that we had a juror that we believed very much was, in our favor, based on the things that you normally look for in a trial, like body language and when are they over there nodding and agreeing and when are they distracted and looking away. And we talked to that juror after the trial. The judge didn't bar us from doing so, and we asked. I asked, like, well, what was it? Where did we fail? And from that little conversation, I came to understand that I had just done a terrible job of communicating what the case was really about. And based on that, I knew I had to get better. I didn't want any other client to experience a loss because I had not been able to effectively focus the trial on what was really at issue. And so, being driven to David Ball, reading that book, adopting that method, I tried another case 6 months later that I thought was much more complicated factually than the case that I had lost 6 months earlier. Got what was my largest verdict of my career at that time. And every verdict since then has been higher. So dramatically increased the size of my verdicts, dramatically increased the responsiveness of the jury to the story of the case, engaged the jury, didn't bore the jury, and by using that method, it really creates a stark contrast between you and your case and whatever it is the defendants are going to talk about when they get up, because none of those folks have read any of those books or made any effort. They're generally going to get up and give a boring PowerPoint and make some promises they can't keep and go sit down. And you typically can notice it in the level of engagement from the jury. Usually within the first minute or two of the defense opening, they realize that the defendant doesn't really have anything to say, and they tune them out. And in many instances at that point, I have established myself as the person who can bring the relevant evidence to them and present the case, and the other side has established themselves as someone that they can more or less ignore. Fair or unfair, that's generally the psychology that you see play out when the defense lawyer stands up and doesn't have anything to say. So by using that Ball method, we establish ourselves as sort of the source of what is going to matter in the case, and we create the environment for what's going to come after with the evidence, and we set the tone for the dollar amount of damages that we're going to ask the jury to award at the end of the case. And so cannot say strongly enough, if you've never read the book, you should read the book. If you don't have the book, you should go buy the book today. I don't get $1 for recommending David Ball, but I would be committing advisor, mentor, YouTuber malpractice not to tell you that if you are trying cases for plaintiffs. You just don't do it. Just don't risk your client's case because you think you're smart enough to come up with an alternative way. It's a simple and straightforward method, and it will make sure that you have your case focused in the right place. Now, Having said that, if you have established yourself as the lawyer in the room who knows how to try a case, and you have instilled in the judge a sense of confidence that you are a serious lawyer and not a time waster, and you've gotten permission to take the time you need to give your opening statement, the promise that I make every judge is this. I will not waste 1 minute of your time. I will not repeat myself. I will say it once, and I will sit down. And, since I adopted that ball method of opening statements, I can tell you that I have been able to do that, and that I haven't wasted time, that I haven't repeated myself. I've given an unobjectionable, very clear opening statement that has set the tone for success. And that's exactly where you want to be if you are the plaintiff with the burden of proof, and all the defendant has to do is sit over there and throw fireballs at you because they don't have to prove anything. So, David Ball Damages, version 3, get that method, learn that method, follow that method. It is the path to success. And if you do that, you can expect a jury that perks up when you get up to question people and talk and put the evidence in the record. And you can expect to have their focus and attention. And if you will do that, you will have set the stage for success. And this is not the longest video in the world. It doesn't need to be, because it's really, I could have come on and just said, hey, by David Ball Damages, follow the method. Saved you the background story. It could have been 30 seconds long, because that's really what it takes, especially if you don't have experience, you haven't done it a lot, and you're a little bit worried about, can I do this well? If that's you, you should be a faithful adherent with no deviation to David Ball's structure for giving an opening statement. It will solidify everything else you do in the case. Thanks again for joining. Always a pleasure to share with everyone who wants to learn and hear and gain any insight I can give. If you like the video and it's useful at all, please like and subscribe. Tell your friends, tell your colleagues, tell your associates, tell your law school professor, whomever. Thanks so much for taking your time. We know it's valuable. Look forward to sharing with you again in the future.